the magistrates.
Good evening, Sugapepper fans. It's your host, Onana Afulo, back again on Sugapepper, the Wonder Woman edition, and we are continuing with our 5-part series. Today, on our 3rd episode, we are streaming live from Busia Law Courts. We are with Honorable Lucy Ambasi, who is going to give us a review and also address sexual and gender-based violence in the judicial context. Welcome to the show. Tune in, and if you have comments, just post them on our comment section, and we shall ask her, and she will respond. Thank you so much, and tune in. Welcome to the show, Honorable.
Thank you, Nana.
First, start. I know I've introduced you, but yourself and give us a small introduction about yourself, your family, the schooling, and the career as you are now.
Good afternoon, viewers. My name is Lucy Ambasi, also known as Mama Champagne. I'm the Chief Magistrate, Busia Law Courts, previously Chief Magistrate in Meru Law Courts. I'm a lawyer, now 28 years in practice. The University of Nairobi, whereafter I attended the Kenya School of Law. My career has seen me work in various places, starting with private practice, where I had my own law firm, before moving to join the government. And when I worked in the government, I worked with the Attorney General's office, where I worked as a prosecutor, I worked as a public trustee, I worked in the Treaties and Agreements Department before finally moving to head the Legal Research Department. I joined the judiciary in 2016 as a Chief Magistrate, and I have been holding this office for the last 4 years.
4 years.
Yes.
Congratulations.
Thank you, Nana.
So we started this 5-part series. Our first episode was about rescue and tracing of victims, especially of rape, defilement, sodomy, and also assault cases. And then last week we had a clinician talking to us about the medical procedures and the processes of handling victims and survivors of these cases. So we saw it a need to just come and hear from you what magistrate, judges, what they look at when they are prosecuting these cases, because sometimes you get a lot of backlash from the community, the society, like huyu mtu kwa nini mulimpatia miaka 30, angefungwa miaka kabisa, hiyo kitu yenye alifanya haikuwa hivi. So I am hoping in this interview we are going to address this and also make the community, the society aware of all these processes.
Thank you, Nana.
Yes.
Okay. Let me start by first saying, when we talk about SGBV, we have 2 components. We have the sexual violence part of it.
Yes.
These are acts of rape, these are acts of defilement and sexual in nature, and they can be against a man, a woman, a child,
Yes.
a transgender, any sex.
Even old age.
And it can also be across the ages.
Yes.
Then we have the gender-based violence, which are acts of violence, not only physical, but psychological, economical, and this can also be both ways, against men or women.
Yes.
But what we've noticed is that in Kenya, it's mostly against, victims are mostly women.
Women.
Yes.
Yeah. Tell me about your first sexual gender-based violence case that you handled that is very vivid to you.
Yes, that one I will never forget. I was newly posted in Meru Law Courts, and I took over a file where the accused person was a teacher who had been charged with defiling 11 school children. He was not just a teacher. He was deputy head teacher.
Head teacher.
And what he would do would call these girls to the staff room. And these girls were girls in class 2. We're talking about 8, 9-year-old girls.
Yes.
So when I first came to court, I saw my courtroom half full of children. And I thought I had a school visit by children, by a school.
Yes.
Just to remember, there was a case I had read about the previous evening that was coming, and I realized this was the case because all the 11 children had shown up to testify. And it is not, it's actually very traumatizing when you imagine when you hear what was transpiring. He'd call these girls to the staff room and finger them using their private parts to the extent of breaking their virginity. And this was not the first school that he had done this. And it took the community to actually riot for the teacher to even be suspended from being a teacher. I was to later learn that teachers are supposed to be immediately suspended if there's a complaint of such a nature facing them. Because he had not done this. This was not his first school. It's something he had been doing.
Yes.
Eventually, after hearing all the children, after hearing the doctors, after hearing the evidence of the parents and other evidence that the prosecution gave to me, I found this man guilty. And because the children were under 11 years, he was actually supposed to get 11 lifetimes. Okay. But in law, you cannot give 11 lifetimes
because somebody has only one lifetime.
So he got his 1 year, his one lifetime sentence. And perhaps the viewers may wonder, what about the other children? But you cannot sentence, unlike the US where you hear dramatic sentences.
Yes.
The law here provides that you commit some, you sentence somebody to one life sentence where they have multiple sentences to serve in one charge.
In one charge.
Yeah. So that remains a case that completely traumatized me. And I think it was also good that in that it prepared me in knowing how to deal with children, victims, survivors of defilement, because our courtrooms are not designed, they're not children friendly. My courtroom is actually in the same setting as this. Okay. So you can imagine the child is sitting here and is facing the defiler there. And it is at that point that I started developing some creativity in my sitting arrangements. The law allows us to take care of children who are vulnerable in giving evidence if they are unable to. So you can even put them sitting in a particular way so that they don't face the victim. Because some are so traumatized that when they start testifying, they tremble.
They don't want the eye contact.
They tremble, they fear, they start shaking.
Yes.
Yeah. So it was an eye-opener. It taught me a lot of things. And it remains
vivid in your memory.
To remember.
Was that the first ever case? Because you're saying you experienced this case on the judgment part of it. As a prosecutor, do you have any other case that you also remember vividly?
While I was doing prosecution, it was in the old days where the prosecutors, the professional legal prosecutors were only doing murder cases in the High Court. Okay. So you remember the new prosecutors came in with the 2010 Constitution. Yeah. And although I was still with the AG at the time, I had already moved to another department. So I did not have an opportunity to actually prosecute a defilement case. Okay. Yes.
As a female chief magistrate and also as a mother, you told me you have a daughter, and you're saying you felt so moved when you entered the court and it had pupils in the courtroom. And usually sometimes for judges and magistrates, people that you like the judicial officers, the most challenging thing, also the backlash that comes from the community is that why female judicial officers are emotional when they come to SGBV cases. Can you make a comment about that? And do you separate emotion from logic in your line of duty when processing these cases?
Yes, Nana, that's an interesting observation. And actually, some of my male colleagues in the profession,
Yes.
and by this I mean male lawyers, have labeled women magistrates as being very emotional when it comes to defilement. Are we emotional? Are we ruled by our hearts, our emotions, or by the law? My fidelity will always remain to the law.
Yes.
So long as the three parameters required in meeting at the threshold of proving a defilement case, that this was a child of a certain age,
Yes.
that this child was defiled by this person. The identity of this person is beyond reasonable doubt
yes.
whatsoever. If it was at night, was there light? Did he know this person? Was it a proper identification? And that this person is the person who did the penetration. Those will be the guiding factors for me when I'm making the decision.
Irrespective of gender.
Irrespective of my gender, of my being a mother, what will guide me is what are the facts that have been presented before me.
Okay.
Fidelity to the law.
Fidelity to the law.
Emotions take a second seat.
Do you have the same, because I am basing on you saying that you saw these children and something in you was a little bit caught. Let me use the word caught. So have you ever sat at a proceeding for a sodomy case?
Yes. I have
and did you possess the same emotions?
Absolutely. Again, some two boys, they are lured into the forest by a man they knew and sodomized in turn for a whole day. A lot of damage was done to the boys. And whether it's sodomy or rape or defilement, or whether it's a girl child or a boy child, the emotions remain the same. In fact, as we speak, the boy child, the teenage boy child in the Romeo and Juliet cases, we have a lot of young men out there who are facing 15 years of jail time because they had experimental sex with their girlfriends who are underage.
Underage.
Experimental consensual sex. But unfortunately, it's only the boy who is charged. I feel the same for this boy as I would for the child, for the girl child. So my motherhood and perhaps women, we are created differently.
Naturally.
Perhaps women, we feel some things differently, and our perspective may be different from my counterparts of the opposite sex.
Of the opposite sex.
Yes.
Yeah, because naturally, you see, you're the one who carries the baby from as small as zygote to it developing into a fetus to a baby that is delivered. So you see, you have internalized first the parenthood of either your son or your daughter, and then the opposite gender starts when it is out, and it's a different kind of feelings and emotions towards a child. So I think that is a natural thing, but then, as you say, fidelity to the law is what guides you. You were talking about 16 to 18-year-old males that are experiencing.
Yes, we have a lot of cases, and this is something the Emeritus Chief Justice Maraga commented on, and it has always been a an idea whose time has come, and I agree with him entirely. Because he noted and commented that a lot of our boys are going to languish in jail for 15 years because they did things that are expected of young men growing up.
Yes.
The girls, on the other hand, will not be charged. In fact, in a lot of these cases, what I found is that the parents of the girl are the actual complainant. The girls sometimes even make very difficult and hostile witnesses. Some will even refuse to testify.
To testify, God.
Because they know it was consensual.
That was my boyfriend.
Yes. And it is unfortunate that we've not been able to amend the Sexual Offences Act, because in my mind, the spirit of the Sexual Offences Act was actually to get to the defilers. These people who were spoiling our 9-year-olds, our 10-year-olds.
Yes.
Yeah. And you are an adult. I'm talking about a whole adult. That there's something not right with that. Is the spirit of the Sexual Offences Act. I don't think it was meant to penalize, and perhaps probably in our time, if the act had been there, maybe many of us would be in jail. And you see, the consequence of that is, if we have a lot of our boy children going to jail, who is going to marry our daughters? What is the how does that affect the balance, the social economic balance? Because it means we are sending boys out at for 15 years when they are 16 years.
Yes.
Come out at 30. What will that boy be doing at 30 years old?
They will only end up in Jengo and casual jobs. Yeah.
Fortunately, in my case, I tend to fall back on the case of Muruatetu. The Muruatetu case decided that it is not necessary to give the mandatory sentence
as prescribed
by the law.
Yes.
You can look at the circumstances and see that giving a mandatory sentence is not necessarily the best option. You look at the sentencing guideline, we have a sentencing policy, be guided by it, and you weigh and see what is the best option for this. So that helps me quite a bit, because I feel it is oppressive to be sending the boys to prison for 15 years.
Okay.
Yes.
When you talk about sentencing, can you give us an overview for defilement and rape cases? Like what are the maximum sentencing for these offenses?
Okay. The Sexual Offences Act came during a time there was a lot of outcry because the defilement was at an all-time high.
Yes.
And commonly known as the Njokindungu Bill, named our Supreme Court Judge, Lady Justice Njokindungu. It brought very harsh sentences. Defilement for a child of 0 to 11 years gets you a life sentence.
Life sentence. Defilement
of 12 to 15 years gives you
20 years.
20 years.
20 years. 16
to 18, which are the boys I was and the girls, the teenagers I was talking about, is 15 years.
15 years.
Yes.
And for rape?
For rape, the sentence varies from 5 years to a life sentence.
A life sentence.
Gang rape, mandatory sentence, life sentence, because that is a lot more aggravated.
Yes.
Yes. And defilement cases always come with an alternative count. Okay. In case the main charge of defilement is not met, then the court can fall back to the alternative count of attempted defilement, which gives a minimum of 10 years.
Of 10 years.
Yes.
Now, for the sake of viewers that may not understand what an alternative means, or the preferred charge when the defilement issues are not met, what do you mean when you say that, for purposes of clarity to our viewers?
Okay. As I've said, the three elements for defilement are categorized by the age of the child, the identity of the perpetrator, and the actual act of penetration. But there are instances you can find there was actually, the ingredients are there, but there was no penetration. The medical report will read that the hymen was intact, which means he may have tried, but he did not penetrate.
Yes.
That is why there's always the main count, which is defilement, and then there's the alternative count of committing an indecent child.
Okay.
An indecent child is defined in the Sexual Offences Act as any attempt to have the private part. Private part is defined to include touch that of another person. So you can fall back in case you find that the threshold for penetration was not there. You fall back to defilement. So that, remember, defilement is never done openly. This is always a secret act.
Yes.
And there'll be men who will probably masturbate with a child without necessarily having sex with them.
Okay.
And that is now where you fall back on the indecent because they'll do their thing, probably rub themselves on the child until they achieve whatever it is they hope to achieve.
Okay.
Then you fall back on the defilement, on the attempt indecent act.
Okay.
Yes.
Okay. Now, Mary of Rape said she deals with tracing and rescuing these people. Then she brings them over to the referral hospital. There's the new GBV center where they are met with the clinician, and then they have to do the P3 form, and then there is the other form that they do before it is given to the police who do the investigation, and then handed to the prosecutor, and then that's when it reaches to you. So tell us, what guides you in all these, how do you arrive at a judgment that this person has to get 15, or this person has to get life, or this one has to get 20, and stuff? Because sometimes it's like, huyo mama hata sijui kwa nini alifanya hivyo, na penye yeye ni mama hakuonea huyo mtoto huruma, kwani yeye hana watoto wasichana pia? No. Some of those intricacies that
in sexual offenses, at least it is the sentences set are mandatory. What will happen is I'll be brought a file like this, and it will have something that is called a charge sheet. This is a fresh file.
Okay.
All that has been done is the accused person has appeared before the magistrate and has been told on this day, at this time, in this place, you did this to the vagina of a child initials aged so many years. Okay. And you have to make sure the accused person understands the language you're using to read him the charge.
Yes.
Then he answers, is it true or is it not true?
Okay.
This is how I start all cases. If he says it is not true, then we enter a plea of not guilty.
Not guilty.
This means that I will now have to be the neutral arbiter to hear this case.
Yes.
I have to hear the child's, the accuser's evidence through the office of the ODPP as presented to them by the police.
The police.
So each case has an investigating officer who compiles and follows up the witnesses and they liaise with the ODPP. On the other hand, I will have the accused person. And remember, as a neutral arbiter, I am there to protect, to balance both rights. Because as far as the accused, the victim or survivor has the right to prosecute and continue with the case, remember the accused person also has rights.
Yes.
The right to bail, the right to bond, which is
To be judged fairly.
which is a big issue.
Yes.
The right to be judged fairly, to know your case, to understand that your case in a language that you understand. The right to a counsel if you can afford one, and if you can't, there are instances we must provide a counsel for the accused person.
Yeah, okay.
So as a neutral arbiter, I will start on a clean slate with a clean file like this. And then when we start hearing, I record. The first witness said this. The second witness said this. The third witness. And after a few years, a file that started, this thing will have become this big. Because every time anything is said, it is recorded, it is written. This is 2017. I can see the magistrate who was there, who was the court clerk, what was said. Okay. It is recorded.
Yes.
So for me, at the end of the hearing, I will have had all the evidence that will come from the prosecution.
Yes.
I will hear I will be given the medical documents. I will be given the P3 form, the PRC kit, I make a decision from what I've had. Okay. Is there a good enough case to put this person who has been charged on their defense? Okay. If so, then I'll say that I'm satisfied that there's a case a prima facie case, a case at first glance. Now I want to hear from the defense. Okay. Yeah. Then I hear from the defense, and hearing from the defense also counts in when you're sentencing, because when you're doing the sentencing now, you'll consider, were there any aggravating factors? Yeah? Like, how many times was this child assaulted by this person? Was it a once-off? Was it something he kept doing? Was it something, the situation surrounding? Okay. Then I'll also listen to the defense. Sometimes you'll hear the defense and it overweighs even the prosecution case because they can prove they actually did not do. They can prove all that has been presented is wrong. This is the correct position. So that is probably how we go about hearing a case in summary.
Okay. Now, you have shown us a file that has so many papers. How are you able to keep up with that? Because you not only just handle one case.
No.
And Mary was saying she has so far dealt with 13,752 cases as of when we were doing the show. And I'm pretty sure you also have statistics. And before we started shooting, you had said that defilement cases for 9-year-olds are so rampant.
Very
how
rampant.
are you able to keep up with the paperwork and also just balance your own life? Because this is too much.
That's what I signed up for. But the one thing I like that the former CJ and the CJ before him, Mutunga, did was the process of digitizing court records.
Nice.
In fact, as we speak now, in Milimani, I believe in the course of this week, there were about 790 clerks who were scanning these documents so that they could be saved digitally.
Yes.
Because as you can see, these are papers. Sometimes even reading somebody's handwriting is a bit of a challenge.
Clarity is an issue.
Clarity, a lot can get lost. But if this is digitized, if we get to fully digitize our records, a lot of this information, the integrity of the information can be saved for the future. In fact, I'm happy to announce that Busia is going to be one of the one court I've really fought for the digital system of recording.
Nice.
We're going to have a system where there are microphones that are set up, and everything that is said is recorded and transcribed. So there's not a word lost.
Okay.
Anything that comes out from the other end is what has happened during, and of course you can imagine you are writing and you want to see, and you want to read the other side, you want to see the demeanor.
Yes.
Who is somebody lying? Is somebody winking at them and telling them no? Because that happens, by the way.
And that cannot be recorded, or it's also recorded.
Yes, you will. I record my observations.
Okay.
If a child is crying, I will record the child is crying
or whimpering.
If the child is shivering, I will record that.
Okay.
Because that is the only way. If I move from Busia, whoever takes up that file, to get to feel and understand what I observed is by my recording everything that I see.
I think that's a brilliant thing because I'm imagining this file is made of paper. What if it is soaked in water? What if there's a calamity and you know it is soaked in water, or as you're transporting this file from one office to another, a paper just flies out and it is the one key evidence that will either acquit or convict an accused. See, those are actually such a challenging thing.
But the good thing is one of the things we've been trying to do and we are fighting so hard to do is to get rid of, to finalize cases that are 5 years and older. All old cases are fast-tracked. They are given priority during the hearings. In fact, if I see there's a 2015 case that is still outstanding, and the diary, already my diary for criminal cases is in May, I will say we are putting it for next month or next week, remove the 2020 case, so that we're able to move to remove the backlog, so that we reduce the risk of things like that happening. Yes.
Can you comment about files getting lost? Nasikia tu file yangu ilipotea, kwa hivyo hiyo kesi iliisha hivyo.
Even if your file gets it has been known to happen. I will not lie. It has been known to happen.
Yeah.
It has been said to happen. But a file disappearing should not mean the end of a case, or that is the end of the justice system. No, it doesn't.
Yeah.
Because remember, other than my file, the police have their file. The witnesses are still alive.
Yes.
They can record other statements. We'd rather open a new file and hear the case from square one. And we have done that several times. Because by the way, one of the rights of an accused person is that when a new magistrate comes to hear their case, they have a choice to request for the case to start afresh from square one. For defilement cases, unless you show me very good reason, I find it double traumatizing to recall the victim, to repeat the same story, to be subjected to cross-examination, to be brought to these strange courtrooms that they don't
are
even
not child-friendly for kids,
which are not child-friendly, and you don't even understand what is happening.
Yes.
Consider too, this is Busia, where we only have one court. People have traveled from Funyula, from near Mount Elgon, Malaba and beyond, going this way, Nambale, to almost near Mumias.
Yes.
And then you are telling them, some of them can't even afford fare. And we even have to pay witness expenses. We have an account, fortunately, for paying witnesses expenses, where we find that witnesses have come from far and they are too poor to, we'll ask if they have fare, if they need to be assisted with fare. But we can recreate a file. So even if a file gets lost, it is not the end of justice. So long as you're willing to get your case heard, we will start afresh, and now we'll make sure that file is under lock and key and 24 hours watch.
Okay. You while mentioning about the processes that you put in mind before you deliver a judgment. You made a comment that a bond is such a big issue. Can you clarify on that?
Yes. An accused person has a constitutional right to be given bond or cash bail. Cash bail is where they pay cash, and the cash is held until the case is determined. A bond is where we ask you, give us a title deed, give us a logbook worth this much, and give us somebody who will be your surety to say that they'll be making sure you attend court. Bond is a constitutional right, and every accused person is entitled to be given bond. But it is not an absolute right. You have to consider other circumstances.
Yes.
We work very closely with the probation department, and in cases, particularly in domestic violence cases, where you see Lucy Ambasi versus somebody Ambasi, and you suspect, because remember, you don't have facts, and it doesn't say is the wife or is the husband, but you suspect this could be a domestic violence setting. We work together with the probation office and tell them, please do for us some background search, find out if this witness is going to be safe, find out if the accused person is going, and remember, we are neighbors to Uganda. A lot of people cross over to go and hide in Uganda.
Justice, yes.
If this person doesn't seem to be known the village, because the charge sheet will tell you he lives here, he's from here, but you don't know everything.
Yes.
Do for us research, because the bond terms will be determined by, is this person a flight risk, first and foremost. Because you don't want to give person a bond and they can afford, even if it's 10 million, just for them to cross to Uganda and disappear forever.
Yeah.
Is this person going to interfere with witnesses? Because if this is the husband and the wife has reported a case of assault, kutakuwaje that night in that house that evening?
Inhabitable.
It will have now, it might escalate to murder.
Yes.
Are these child defilers neighbors? Do they live nearby? How likely are they to influence? Because if I hear a case is from Nambale, unfortunately, Nambale has developed a reputation. Because there are instances of trying to buy off witnesses. And if I hear they are likely to interfere with witnesses like that, then bond does not become an automatic right.
Okay.
You will you will do the hearing while in custody. And I will deny you bond.
Yeah, for as long as the proceedings take until you do an acquittal or a conviction.
Yes.
Okay.
And even when I give you bond, then the victim comes and says, this person has been threatening me. It has happened before. This person has been threatening me. Your bond will automatically be cancelled. Then you spend you do your hearing from outside.
Okay.
Yeah, because like all rights, no right is absolute.
Okay. I want to ask you about coaching, because sometimes you have instances of children that are coached against an accused, either because of malice or bitterness from whichever parties. Are you able to tell in a courtroom setting that a child has been coached in your experience as a lawyer for 28 years?
It's very hard to tell. Because first and foremost, I think our brains are wired to believe that a child to have come this far, surely they must be coming to testify to the truth. But unfortunately, experience has taught me the opposite, much to my sadness. Some of the most innocent looking people, when you finally get to convict them and ask for a pre-sentence report, you get shocked. I have had a case actually where some two girls were coached by their mother to lie against the grandfather. And in that case, I remember throughout, I had misgivings. I was observing the grandfather, and I had some misgivings from the way he was asking questions.
Okay.
The bitterness, and begging. He was actually begging. He was very emotive, begging, why are you lying? Just tell them the truth.
Yes.
So when I put this man on his defense, because I had no reason not to believe the children, the medical report was there. They had been penetrated. They said it was a grandfather. I had been convinced 100%. But when this man was put on his defense, his first witness was his wife, who says, we've been staying with these children because the mother abandoned them. They've lived with us throughout.
Yes.
I'm not, and they called other women, among them even a woman who said, we even tested these children the traditional way and found they had not been defiled. And it was in the presence of the mother, the liguru, and Sijui, the whole, the Sanjes, and these children were not defiled. And I let the man off because the evidence, the defense evidence, way overweight all the evidence I'd had from the prosecution. So it does happen. Yeah.
And I think in that kangaroo committee setting, they'd already tampered with the evidence, because once you insert your fingers trying to
measure
and stuff, by the time you get to a clinician, they're not able to tell if
yes,
this is the origin, like this has not been tampered with.
It's true, and once now the Sanjay's, in fact, I'd want to tell them, please don't do those tests.
Yes.
Let the doctors come do their work.
Okay.
Don't you report to the liguru, let them be taken to hospital.
Yes.
Tunapima, you are spoiling, because if it actually happened, you might break the hymen of the child.
Okay.
Then I will not know who the perpetrator was.
Okay.
Was it this person, or was it the person who put in the finger?
Okay.
So that can also tamper with the case.
The first, you're basically saying that the first touch and measure of any victim or survivor that is claiming penetration should be from a clinician.
From a clinician, a medical doctor who is able to, one is able to write a medical report, fill in the P3, fill in the PRC kit, and is an expert witness. Yes. Somebody who is trained in knowing how to medically measure and assess sexual defilement. Because as Sanjay, if you tell me nilingiza, what is you are not an expert witness.
Yeah. Yes.
So the first place, and they are always told, report the police, the liguru, the chief, somebody, then straight away take the child to hospital. Yeah. And I'm glad we're working with a lot of sponsors who are working with the clinical officers in this region.
Yes. We've
had sessions with them and emphasized on what they need to look out for when they also they are assessing the children who have faced defilement.
Okay. You've said that sometimes also the defense can have such a good rebuttal that the case is thrown away. Do you have any instance that you can give us where, like, a defense, like even a challenging case that you sat in on, where you thought like this the victim or the survivor had everything going for her, and then the defense just came with the rebuttal, and you're like, weh, sasa hapa, I really don't know, like, what is what and who is who.
I see a lot of that, sadly, with our teenage girls. And particularly teenage girls who are looking for what is commonly known as sponsors, sugar daddies, who are a little too clever and go for entrapment of men.
Yes.
And the men may not be necessarily even boys their age. They may be older men, but men with money.
Yes.
And even without going to the defense, because the process of the court is that you hear the plaintiff, you hear the witness, and then after the witness has testified, they are asked questions by the accused person. So you will hear instances where when this man starts asking questions and you hear the demolition he's doing to the evidence he's giving, the girl has given, you are devastated. You are quite certain, because they will tell you, you walked to my house, you brought yourself.
Yes.
I remember one time, one man almost crying. You told me you had finished Form 4. You told me you had an ID card. You told me you were over 18.
Yes.
You came and stayed with me in my house. Then you are like, then why are we doing this case? If this evidence was known, so you find the case is demolished even before it started. It's begun. So it's a little sad that a few of the girls, and you see that can make you a little what is the word? Overcautious, because now you are like, is she telling the truth or is she not? But as I said, at the end of the day, fidelity to the law and listening to both sides and hearing the two versions is what will help you decide.
And I think also for such particular cases, the demeanor will always just judge you, like drive your judgment. Are you able to tell from the demeanor?
Demeanor is one of the things that we are required to observe when people are testifying.
Yes.
Just like even you, when you're listening to someone telling something,
story, yes,
you'll be like,
rada ni gani, hii form hapana.
The two are not going together.
Yes.
Because when you say that, this man threatened to kill me if I told, and then the next thing you're saying, your mother found you outside his house sunbathing to rescue you, and you even refused to go home. Already you are like,
no. That account is already hostile.
That account is contrary to the evidence that is being presented.
Yes.
Yeah. But unfortunately, we have no control over the prosecution because it's an independent constitutional office.
Yes.
So if they decide to continue with the case, we must do our duty, listen to all the evidence they present before now we make the decision. Okay. But that counts heavily, of course, against their case.
Okay. Now for that particular issue where the man says that uliniambia uko 18, ukaniambia uko na kitambulisho. Isn't that already grounds for criminal liability? Because when somebody tells you that akona ID, you must ask for an ID. Proof of ID is already proof of maturity of age, which is already consent to have sex. Yes, consensual sex.
The first time Justice Chitembwe threw out a defilement case, and the words he used were that this girl behaved like a mature person. She carried herself like an adult. She took herself. He was criticized world over. I remember it being called the worst, even getting an award for the worst decision. But unfortunately, we have come to see that there are a lot, very, very many of such cases.
Yes.
Where girls pretend to be over 18. And I think they are built. You'll see them even in court. You'll even think they are 20-something.
Yes.
Yeah. Although that is no ground because it's a statutory offense. There are times when it now goes to beyond not just doubting the age or you should have known better. When it's a question of entrapment, deliberately lying, and telling this man, but then again, each court has a different opinion. You remember the Kisumu case? The lady who dated this young man with the rastas and a motorcycle.
Yes.
And the court held, the court held no. He was still a child.
He was still a child.
Yeah. So each case and each set of facts are the ones that decide which way you will go. And
also, you know, the normal teenager of yesteryears is also not the normal teenager of. They are so empowered, so informed. In like Ata Hawakai teenagers, yeah, when somebody now whips out their birth certificate or their ID, that's when you're like, what? You like the way you are, somebody can't tell your age.
Yeah.
Now, basing on that, so do you advocate to reduce the maturity age to a particular age, or you just stick to the constitutional 18?
I absolutely believe that it's long overdue to consider the amendment of the age of consent.
Okay.
Because we always borrow from best practices in other countries.
Yes.
And our leading country of choice is always the UK. From whose law we borrowed, we adopted, not even borrowed, we adopted wholesomely.
And ratified, yes.
And they have moved on with the times. They have changed their laws with the time. Like our Succession Act. You look at our Succession Act. I'm a widow. Do you know, as a widow, I'm not supposed to own my husband's property. I'm only supposed to guard it. If I want to sell one of the houses, I must get permission from court. But this is property we work together. But him, if he's a widow, if I had died, there's no such a... But you find the UK moved way ahead and changed the Succession Act so that they could bring in the equality of women.
Yes.
They've done the same with the age of consent because they realized this thing of crying that underage children are having sex, let's deal with it by accepting the reality on the ground.
Yes.
I would really support the motions that have been proposed to consider reducing the age of consent, because in this global village that we are in right now, a lot of our children are way informed than years back. Number two, we no longer have the social fabric to supervise our children the way we could previously.
Yes.
You know, before, if I was working in the village and I'm seen with a boy, anyone is at liberty.
Yes, to break a stick.
Yes, to take a stick and they say you can't touch people's children. Even if they are wearing what or doing what or drinking what, you sit back and watch, because that social fabric is no longer the same. We don't police other people's children.
Yes.
So I would move for, let us accept the reality on the ground that our children are learning a lot more way younger
than our generation. Okay. The biggest challenge as an advocate of social justice for sexual and gender-based violence, our biggest challenge is the issue of kangaroo courts. So many cases do not see the courtrooms, the boardrooms where you can actually go through the processes to attain like a fair process for these cases, is because people want to negotiate at the grassroots level. Akujeni, liguru ama wodadmin, or even the aunties and the uncles, the parents themselves, minus the accused, to, you know, tumalizane hii mambo hapa chini.
Yes.
what are your sentiments on that?
One,
just speak to the custodians and parents of these victims and these survivors.
Yes. Number one, I want the parents to know that it is illegal. It is an offense. You are covering up an offense involving a minor. A minor you are supposed to be protecting. By taking money as compensation, you are committing an offense. The only person who can withdraw a defilement case, this one you cannot even consent like you do for assault or for robbery, is the ODPP. So remember that you're already committing an offense. Number two, your primary duty as a parent is to provide safety for your own child. If your child has been harmed, they have the courage to come and tell you, and instead of protecting them, you proceed to sell their innocence. How are these children ever going to recover from that trauma? Because that is double trauma. That you've been subjected to this. Your parents didn't see it as a big deal. They'd rather take money and forget about it. And I'm glad that Mary from RIP is really working very hard at the community level.
Yes.
I think we need a lot of public publicization of in the information that it's an illegality. You're committing an offense. You're obstructing justice, and you can be charged alongside the defiler. Yes.
Okay.
So please do not defilement cases should never ever be covered up.
Okay. You say that there is an account for witness logistics.
Yes.
To enable them to come in and give accounts of how is that one attained?
All one has to do is we ask. They are supposed to ask through the office of the prosecutor.
Okay. Because
they'll say we came from. But I also make the announcement that if you have come to do a hearing in this court and you do not have the transport, and particularly if your case was not heard for one reason or another, please tell us where you've come from, how much fare you paid. Utakuta ni 200, 50 ati kutoka hapo na boda ni 50, then 50 from here to here, then going back the same 50, Yes. 200 shillings. So fortunately the judiciary has a vote for that. Okay. And we always let them know that we have a vote for witness expenses. Yes. We're also working very closely with the children's department, who recently informed me that they've stocked up their SIPU units, the child protective units at with pads, diapers, all feminine hygienic things that may be needed. Okay. And at least now we are able to work with them, so that I tell them, if you know there are girls coming to court, if they need pads, make sure they get their pads. If it's lunchtime and they've not gone for lunch, let them know they can walk over. Apparently there's milk and bread, they can be fed. Okay. Yeah. Okay.
That is such a good gesture, because somebody might actually just miss out on fairness, because justice should be, in all fairness, administered, and it's so thoughtful to have witnesses also guaranteed, like to come and give an account, because in as much as there is medical evidence, I don't know, and stuff, the witness account is important. It's very, very important. So viewers, as we come to the end of this episode, next week we shall have Irene from FLEP, also still going to address the witness logistics part of handling sexual and gender-based violence in the judicial proceedings. Your Honor, as we come to the end of the show, I want you to just look into the camera and give your final message out there for all practitioners, all shareholders, all collaborators, all advocates that are in this fight against sexual and gender-based violence.
Thank you. I must say I have never understood the logic behind going to a 9-year-old, a 7-year-old and defiling them. It has been said that perhaps it's a mental illness. It has been said that there are many women out here of age that you can, it has never made sense to me, and for as long as I'm in this sector, defilement of children will not be tolerated in my jurisdiction. I will give you you will face the maximum penalties with me, because that is stealing the innocence of a child that can never be recovered. And it takes a lot of psychological support even to have them come back to normal, because this is something they live with for the rest of their entire life and affects them permanently. It inflicts permanent damage. So, and I want to thank the other our other supporters. FLEP, you've mentioned FLEP. FLEP has been one of our biggest supporters in our court users committee. Court users committees are committees that are made of stakeholders, so that we're able to address issues together, the police, ourselves, the Children's Department, ODPP. I want to thank them for continuing to support us and our CUC stakeholders. I also want to just let you know that on the 19th of March, we have an open day for the judiciary. We are going to showcase and talk some more about issues that affect the SGBV based issues at the Polytechnic grounds. Yes, thank you, Nana.
Thank you so much. So viewers, as you have heard, there's going to be an open day at the Polytechnic grounds on March 19th. It's a full day. It's a full day event. Get there, ask all the questions. You will get so much capacity building on that day. So please just come forward, and I hope we shall have collaborators also coming in to just understand the processes, because sometimes it is lack of knowledge that you'll have partners clashing with judicial officers for lack of knowledge and also not just understanding the procedures as they are. Thank you so much, viewers, and tune in next Wednesday as we talk to Irene of FLEP, who's still going to address about witness logistics. Thank you so much and have a good evening. Bye.
Bye-bye.